Well, welcome to everybody to the training. My name is Vicki Suter. I'm the Director of Rights and Advocacy, also the lead for our supported decision-making efforts. Caitlin, one of our training assistants, is going to just give us some housekeeping things, and then we'll get the training started.
Absolutely. Thank you, Vicki. So welcome to our second session of our supported decision-making series. Just a few housekeeping things here. If you need rights CEUs, contact Jean Fentner. And if you scroll up in the chat, she did drop her information down there. If you have any questions about that, you can type it in the chat. There will be a survey that I will send out in the chat at the end of the training. So it's just going to be a link that I drop in the chat. We really, really appreciate anyone's feedback. So we appreciate when you fill it out. For questions, there is a raise your hand feature. It's going to be a little hand shape on the top right bar of your screen. You can raise your hand. And that'll let us know, that you have a question. You can always also drop your questions in the chat box. And then we will periodically stop and ask if anyone has questions as well. If anyone needs any closed captioning, you can click on the three dots at the top of your screen and hit turn on closed captionings. If you have any other questions, let me know down in the chat. We're going to be monitoring that as well. And Vicki, I will hand it back to you.
Great. Well, thank you. I appreciate everybody who is attending our second session today. We did have about 100 people register, so we're excited that so many people want to get this information. We really started this effort as a part of our OCHN supported decision-making work group. We talked about how could we get people information about supported decision-making so that they know of all the tools and options that they have available to them to lead the best life possible. And that, in partnership with Mary from the Development Disabilities Council and Kimberly Hoga from Detroit Wayne Integrated Health Network, culminated into this 10-month series about various aspects of supported decision-making. We really are excited. We had great attendance for our first session, and we got great attendance for the second session. Sometime in the future, we will have these recorded sessions on our website as well as a supported decision-making website presence on our website. We haven't quite gotten there yet, but we hope to do that. So again, thanks to our partners. This is not possible without many people's assistance, including our many trainers that we'll see over the 10 months. As well as our training department, Caitlin and Trish, who have helped us make sure that this runs smoothly, and appreciate Kimberly Hoga's her effort to get the word out. I'm sure we've got such great attendance because of their support of getting the word out about the trainings. So with that, we want to go to the next slide. So for today, we are covering powers of attorney. And Lisa Lapine, who is a lawyer and knows many things and been an advocate for a lot of years, is the CEO of ARC of Macomb County. And we also have Mary, who is our partner in this training from the Development Disabilities Council. And, she is a longtime advocate, has great information as well as great examples about many of the tools that we're going to talk about over this training series. So I'm going to turn it over to Mary, and Mary just going to provide us with some brief information about supported decision making, and then we can lead into Lisa.
Okay, hi everyone, and thank you for being here today. So the council has, as part of its current 5-year plan, infusing the idea and the tools and information about supported decision making throughout Michigan. So as Vicki mentioned, I work with what we call the Supported Decision Making Advisory Group. Vicki and Lisa and Kimberly and a number of people from around the state, including self-advocates, are involved in that group. This training is one of the products from that group. We've created a base presentation, and then in many areas of the state right now, we're having requests for more drilling down and getting more information about specific topics. So that's really what spawned this 10-month series. And we're getting similar requests from other areas of the state as well. So just keep that in mind. We do have resources on our website. If you go to the Michigan Developmental Disability Council website and click on the supported decision-making button, you can access the video that we saw in the first presentation, as well as other tools that were talked about, the supported decision-making 6-page brochure that was created by the advisory group, our position statement, as well as a 3-part breakup of the supported decision-making summit, where we brought in national experts to talk about that in 2018. So you can view all that information on our website. So I just ask that you keep us in your back pocket as a resource and contact me as needed. That's all I have. I'm going to turn it over to Lisa because she's the real expert on the power of attorney stuff.
Good afternoon, everybody. Thank you, first of all, for having me. Second, I'd just like to introduce myself a little bit and talk about my background to kind of lay a foundation. I think it's useful when we talk about how we help people make decisions or choices to kind of understand where maybe I'm coming from as I do this presentation. I am the executive director over at the Arc of Macomb. I'm also an attorney licensed to practice in the state of Michigan. And at the Arc of Macomb, we are very, very strong advocates for any type of decision-making and alternatives to decision-making and supported decision-making than guardianship. But we also have some folks that we act as guardian for. So I've had experience on all ends of the spectrum with this particular issue and feel pretty confident about being able to explain the differences between the two. If you have questions during the presentation, you want to raise your hand during, I'm happy to answer. But I wanted to start out with this idea or this concept, and I can't push the button. Someone has to push the button for me for the next slide. I want to talk about human nature just a little bit before we get into legalities and conversations. I've been doing this now, as Vicki mentioned, for a little while. I'm actually kind of counting years now. I can say I've been working in this field now for over 25. And this slide, this idea, this concept of human nature is important, and it's the key. How a person is how a person is. And it doesn't matter what legal designation or what way we support a person or what way we say to the world under law that we're helping them. People do what people do. People are what people are. If I really, really, really enjoy eating oranges while I'm sitting on the beach wearing a scarf, I enjoy eating oranges sitting on the beach wearing a scarf. And Mary can tell me you shouldn't wear your scarf at the beach. And Vicki might tell me you shouldn't eat your orange at the beach because you'll get sand in your orange. And I will still sit on the beach and eat my orange with my scarf on because I'm who I am. When we start talking about legal designations and how we support folks, keep that in mind, because the choices that we make to help people when they're making decisions are based at the very core of who that person is and who the person around and who the people around them are and what we might do to help them make good choices or to give them information to make good choices. Is absolutely imperative to remember that no matter who we're helping, that person is who they are. So whatever sticker from the legal perspective we slap on it, that's not going to change. Next slide asks me the question is, when does a question regarding legal authority or support occur? And this is an important conversation. Probably most of the people who are in attendance here understand that until we're 18, our parents allegedly are making our decisions for us, right? And I say that because I'm the parent of 2 teens or preteens, and I'm not sure I'm making any decisions anymore. I may be telling them what I'd like them to do, but I'm starting to have challenges with whether I'm the parent or they're attempting to parent me. That's typical. That's how we learn. But the legal question about when do we or how do we make choices or decisions, it changes right at that magical age of 18. Because that's when the law says you as an adult can make all the choices that are thrust at you. So before we proceed to law, let's just take a minute and think about that. What were you doing when you were 18? I always laugh a little bit because I feel like when I was turning 18, the world was just a little bit different. It was a little bit loosier-goosier. If you got in trouble, sometimes you got a talking to instead of a ticket from a police officer. Nowadays, you go to court and your life can be ruined by making a poor choice. There are all kinds of things that I think about that I did when I was 18 that turns my hair gray when I think about my children doing it. The idea that they can get a credit card, that they could enter into a contract, that they're going to go away to college and I'm not going to be able to see their grades even though I'm footing the bill, it is a little bit stunning to me when I think back to, gosh, how did my parents let me do that? How did they say, okay, at 18, Lisa, go ahead, make all these decisions and choices? So that question becomes really important at 18. It's even more important at 18 for us to recognize that most of us aren't ready, regardless of what is going on in our world. Sorry, I'm trying to, my computer's doing funny things to me. So we're going to go to the next step and say, okay, most of the people on this involved in this conversation today are folks who deal in the mental health system or have a loved one who processes their environment differently than we would typically. And when we talk about processing our environment differently, or when we're dealing with parents, or when we're thinking about how to support differently, there's two laws we need to be aware of. Can we go to the next slide, please? For folks with developmental disabilities, when we're talking about legal designations regarding powers of attorney, alternatives to guardianship and guardianship, we look at the mental health code. The reason I'm making this distinction, or the reason I'm pointing this out, is that that's the law that dictates how you proceed with whatever designation you're choosing. The next slide tells us that the Estates and Protected Individuals Code is the law that we follow when we're talking about folks with persistent and severe mental illness and closed head injuries, or people who are aged or have dementias, or if someone is in a car accident and has a moment where he or she can't make decisions or choices. When the next slide, it tells us, though, that regardless of whether we're using the mental health code, because we're talking with someone who has a diagnosis of a developmental disability, or we're talking about the Estates and Protected Individual Code, regardless of which choice of law we're using, case law and those laws tell us use the least restrictive means to support person that's available to you. And I bring this up because at 18, what's the least restrictive way to support a human being? It's to say, hey, be free. You're an adult. Go on. Do it all. Okay? So the least restrictive way to support someone at 18 is to say, it is okay for you to make decisions and choices, and I'm here to help you with those. Should you choose to have my information, or should you choose to hear from me? So always understand that no matter what we're doing, the law tells us use the least restrictive before we proceed to any other method. The next slide, though, tells me something else about life. And I use this to talk a lot. We talk about circles of support in our field of work, but I think about this in my own personal life quite a bit when I think about decision making, because we have this belief system that unless you understand everything about everything, you can't make your own choices or decisions. And I encourage you to think about your own decisions and choices and your circle of support. By way of example, when my husband and I purchased our property, we got a mortgage. And using the application that we often use in the world that I'm used to, that you have to understand every aspect of it or you can't sign the paperwork, my husband and I should have never been given a mortgage. Because I can assure you that despite the fact that we'd both had some schooling and both of us had had some life experience, neither of us had done a mortgage the first time we did one. We relied on people in our circle to assist us in reviewing the mortgage and making sure we understood the terms of the mortgage and to make sure that we knew or had an idea, a good understanding of what we were doing. I didn't understand the percentage rates. 15 years into it, I still wonder sometimes what I got myself into. I like my house, but boy, did I spend a lot of money. And at the time that I entered into the mortgage, the question was it the best choice for me? In the middle of changing jobs, in the middle of planning a wedding? Is that a good choice? And the reality is when I made that choice, not only did I talk with a financial planner, a banker, I talked to my mom and my dad. I was an adult, but I called my mom and dad and asked them if they thought it was a good idea. I talked to my soon-to-be in-laws. I got help and I got information and I got input to whether this was a good decision or a good choice. I use a mortgage by the way of example because that's something that a lot of us do that we just kind of do and we don't really think about it. But if we apply the same standard that we often apply in the field of supporting people who think differently, there's not anyone, well, I shouldn't say anyone because I don't know everybody on this call, but there are quite a few of us on this call who would have not met the standard of capacity or competency when it came to signing that contract or that mortgage. So keep in mind, our circles of support, no matter how we process our environment, are key. They're so important to decision making, and we use them all the time, whether they're your girlfriends, whether they're your work family or your work husband or your work spouse, or professional mentors, or your sisters or your brothers. We use people all the time to help us make decisions or choices, and we never recognize that that circle of support is something that we can expand on for all folks to make good choices or decisions. And that circle of support helps us with all kinds of things. It helps us with, you know, do you like this guy I'm dating? Do you like this person that I'm involved with? Or do you think I should make this big purchase? So regardless whether we choose to ask our moms, our girlfriends, or the person in the grocery store about whether this is a really, really good purchase, we rely on circles all the time. So this is a foundational basis to everything else I'm going to talk about. Because with that foundation, we go to the next slide and we say poor choices versus the inability to choose. And I want to really make clear, poor choices don't mean that you're not capacitated, and they're not equivalent to capacity. I make poor choices every day, particularly with my diet. That's a huge one right now. And I continue to make those poor choices. And those poor choices lead to things like diabetes and other health challenges that I have, but I'm allowed to make those choices or decisions. And no one says, you're incapacitated, so I'm not going to let you decide. I have the right to make those bad choices or decisions simply because, but it doesn't mean that I'm incapacitated. When we talk about determining capacity and we talk about determining competency for signing documents, another thing that we need to recognize is that communication plays a part. Communication, right now I'm communicating to you all verbally, and I'm doing my best during Zoom, and I really can't, I have a hard time sometimes when I can't see faces because I'm relying on facial responses to see if the point that I'm making is coming across. So every once in a while, I'll see someone's picture and I'll see a head nodding or I'll see a smile and I'm like, okay, I'm hitting the mark. So for me, a big part of communication is nonverbal cues. A lot of people who know me wouldn't say that I can't communicate, because I talk and I communicate all the time. I love to talk. But one of the biggest keys for me is whether someone is telling me through their body language if they're comfortable or not comfortable with the topic that I brought up or the conversation I'm having. In determining someone's capacity or their ability to sign a document, and in my communication with folks, I don't know that everybody can read every page that I wrote. I'm not expecting them to read every page that I wrote. But can I tell if they're in my office willingly? Can I tell that they're with the people that they're with willingly? Those are important pieces of determining whether I feel comfortable when I'm getting ready to do a document. All behavior is communication. I learned this a million years ago. I'm sure everyone on this call already knows this, but all behavior is communication. All behavior is almost better communication than verbal communication, because sometimes people will do what they're feeling more easily than they'll say what they're feeling. I recently read an article where someone said there's a little bit of truth when someone says just kidding, that they're really not just kidding. You know, so how do we tell when someone is using nonverbal communication to tell us something when we really want them to tell us with their words? So keep in mind, whenever we're thinking about how to support folks, we've got to remember that communication comes to us in all forms. This is important because when I go in to sign a document, I look for whether someone has informed consent. Now, the next slide kind of goes through and says communication of information, disclosure, capacity, and voluntariness. The elements of informed consent are really important because I can't tell you how many times I've been engaged with professionals where they'll tell me someone can't give informed consent after meeting someone for about 7 seconds. And they're making that determination based on how ill a person is at the time, or whether the person's coming across as having a challenge with their understanding. And I think about this all the time in terms of informed consent, in terms of myself, when I think about going to the doctor. I go to a lot of doctors because I'm getting to that age where every system seems to have a little slight failure. And every time I sit down in a doctor's office, I think about this concept, and it's a little silly, but I think about it every single time, because they're telling me a bunch of information, and I'm supposed to take all that information in, and within seconds tell this doctor, yes, do this procedure, yes, give me this medicine, yes, do this or that. How effective my consent is depends on a lot of things. It depends on how serious the situation is. It depends on how direct the doctor is. It depends on the words he uses. I always think to myself, I have one doctor who I spend a lot of time, I feel like I'm my puppy. I go like this the whole time he's talking to me, because I'm not really sure what he's saying. And then he leaves and the PA tells me what he said. I'm still not sure I ever understand, but elements of informed consent means that he's communicating information to me. If someone's communicating information to me and disclosing things to me, the capacity issue becomes the next part. How is that person understanding? And then finally, voluntariness. Am I there voluntarily? Arguably, a lot of times the doctor, I'm not there voluntarily, but I am presumably there because I want to be. But with that capacity issue is where we fall into a lot of challenges within the world that we work, because it is not uncommon for people to decide whether someone else has or doesn't have capacity. Capacity is an ability to understand information based on what's provided to them and the possible consequences of the decision. And an important concept of capacity is that it can vary. I might have capacity to make a decision today at 12:35, and 2 hours from now I could lack capacity. Perhaps I had too much to eat and too much sugar for lunch. Maybe I Maybe I drank lunch. I didn't, but what maybe I did. Did it affect my capacity? Maybe I didn't have lunch at all, and I'm not thinking clearly because I didn't eat. But capacity is an ability to understand. Does that ability have to be the same for everyone? No, not at all. Because if I have capacity about one issue, I might have someone in my life who has better ability to explain it to me than you did. Capacity and competence, which is the next slide, is not the same thing. Okay? A competence is a characteristic. You can be competent at something, and it's all or nothing. Okay? Listen, best story ever, I got a flat tire. I am going to be 51 years old tomorrow. Do you know what I do when I get a flat tire? I call my father. I am not competent to change my tire. I never have been. I have no desire to have this competency. Doesn't mean I'm competent to sign a document. Well, maybe, maybe not. But I am not learning how to change a tire today or tomorrow. I will always call my dad first, even if he can't come to me. I will call my dad first so he can tell me, call AAA, lady. I will do whatever I need to do, but that's something I've always relied on him for. If you measured my ability to, or if you measured my competence by whether I can change a tire, I'd be competent. I call AAA, exactly. So when you talk about capacity versus incapacity, when you look at the next slide, you have to realize that it's a legal concept defined by law. And capacity is determined by courts and attorneys. It's dynamic, okay? It can change. Your capacity for something or your ability for something can change. My capacity to practice law, I hope, gets better every year. My professional liability insurance assumes that it does, right? But our capacity changes. As I get older and I have other means to purchase things, perhaps my capacity changes. I am no domestic goddess, but I find that I become less a domestic goddess as I get older. My capacity about taking care of my house is changing because I have the means to ask someone else for help. Assessed capacity can vary according to supports provided. For example, effective communication skills. This is so important when we talk about people who process their environment differently than we do. Effective communication doesn't mean communicating in a way that I understand. It means communicating in a way that the person listening to me understands. That's why I have a hard time on Zoom presentations. For me, part of my effective communication is seeing whether the folks out there can understand, are understanding what I'm saying. Or as we say around here, are you picking up what I'm laying down? Is there a general feeling in the room that everyone's moving along at the same pace I am? Or do I have a group that looks like they're going like this? I don't get it. So effective communication skills can be that nonverbal piece. It can be a verbal piece. It can be how big or how little the words are you're using. It can be whether you're using language that that individual is used to hearing from their family. And it involves others who know the person best, and I think that's so imperative for this conversation. If you think about the people in your life who you support, your parents, your children, your siblings, your friends, you could probably pick one of those folks and tell me something about them that you know in their method of communication that's specific to that person. My husband, when he's nervous, blows on his pump. You know, if we're doing anything and he does that, I'm like, oh, stop. They're not going to think that we want to buy this house, or we're not going to buy this. But no one knows that's why he's doing that. It's what I know. My daughter would never tell you she didn't understand what you were saying. But she won't understand what you're saying half the time because she doesn't listen well. Right? She's not listening. She's listening to walk away from you because she doesn't want to talk. She doesn't like to talk. I don't know how I had a kid who doesn't like to talk, but she doesn't like to talk. Okay? So when you determine capacity, you involve others who know the person best. You know that you're going to get more effective communication when you're relying on that circle of support. I keep adding new slides to mine when I go. But the next slide is key. And we make this mistake all the time. Always presume someone has capacity. It's very simple. Always presume that someone has the ability rather than determining that they don't, simply because they have a way of viewing the world that may be different than yours. So if you start with that concept that all people have capacity, and we started this presentation with at 18, at the magical age of 18, what did the law presume? The law presumed that everyone at 18 had capacity. If you apply that rule and that law, there isn't a single person out there who cannot execute a power of attorney, because you're presuming their ability. So what is a power of attorney and what does it do? It's a document that allows someone or gives someone the authority to manage someone else's affairs. The person's assigned to manage the affairs as an agent. It's voluntary and it can be changed. The scope is defined by what you write in it, and it occurs outside of a court process. I'm going to go through all the law on this and then go to scope in just a second. So the next statement talks about what it actually says, or how you have to define how it has to be written. It's a signed document witnessed by two individuals and notarized. You have to have sound mind. We're going to talk a little bit about sound mind because that's one that catches us up all the time. It goes back to that conversation of capacity that we are having. Consent, it's defined as whether a person knows what right he has and that you want someone else to have the ability to use that right. And I'll talk about that a little bit more. And the agent must sign an acknowledgement of responsibilities. So I gave you the words, I gave you the scope. Let's talk about powers of attorney in general after you've gotten all of that. Okay. A power of attorney is a piece of paper. It's a document. It can be 1 page, it can be 700 pages that says, I am choosing a person other than me to exercise my rights based on what I wrote in this document, and that person is accepting that responsibility. For that document to be legal in the state of Michigan, it has to be signed, witnessed by two people who aren't related to that person, and notarized. The person who signs it has to have capacity or sound mind, and they have to be giving consent. What that means is the person signing it has to have the document explained to him or her in a way that makes sense to him or her, that they understand that what they're signing is choosing someone other than them to do something for them. Okay? When I do a power of attorney and I sit down with someone, when I do an estate plan and I sit down with someone, I very rarely have people who have read every word. Okay? They're expecting me to explain this piece of paper to them in a way that makes sense to them. As the attorney, I'm expecting that person that I'm explaining it to be able to understand how I'm explaining it. And that's where it gets a little tricky when you're doing powers of attorney, because I have to be able to explain it in a way that the person who wants to sign it can understand it. So for Mary, it might be that I explain it every page, every word, or it may be that I explain it by saying, this piece of paper says that these people over here are going to help you pay your taxes, go to the bank, and make medical decisions. Are you okay with that? And the parent might look at me and say, they don't know what the bank is. Okay, well, now it's my job to explain it effectively, because the power of attorney document is a document that can be explained to the person. And as long as the person understands the concept of these are the people who are with me and I trust them and I'm choosing them to help me with this, they can execute the document. What am I presuming when that person sits down? Their capacity. What am I also presuming? That they're there voluntarily. So when we talk about these documents, why is it very, very important sometimes to have lawyer involvement? Sometimes. Because that person is making a legal decision whether the individual at the table with them has the ability to sign the document in front of them, or that they can explain it in a way that they can understand what they're signing in front of them. And that's the key. What happens a lot of times is that, and this just happened recently to me, when I write a document, it's an end user gets it and says, this person didn't have the ability to read this and sign this. They didn't have the capacity because they have a developmental disability. Recently, I was told someone couldn't because they couldn't read or write. Well, that's not anything that I just told you about in the law. Nothing in the law requires that person to be able to read what they're signing. It requires me or a person who's helping them sign it, explain it to them in a way that they can understand the document. It also presumes that that person has what? Capacity. And what does every person have unless a court decides it doesn't? A person doesn't. Capacity. I'll get to that. Actually, that's a really good question. When you do a power of attorney, if you follow all the rules with the two witnesses and the individuals and the notary, the key is that one other piece I should have put in here is a signature. How many people, well, I can't tell where your hands are, so a signature in Michigan, by definition, is anything I mean it to be. So I often have families call me and tell me, well, my loved one can't sign their name. They only print. That's okay. My 14-year-old never learned cursive. I don't know what they're going to do when he has to sign his name because he never learned cursive. They just skipped that in school. A signature is anything you mean it to be. If I say to Mary, Mary, that document that you received from me the other day, can you sign my name to it? That's a valid signature because I just gave her authority to do that for me. If Mary needs to hold my hand to help me sign my name, that's a legal signature as well. So I want to be really, really, really cautious and really, really encouraging to you guys to say, you have to recognize that a lot of things that we think someone has to be able to sign their name or do something a certain way, and that's just not the case. The person has to have the ability to understand the document presented to them in a way that makes sense to them, with the help of the people around them. So, in a power of attorney, I'm going to go down to scope. Okay, there's all kinds of powers of attorney, and this is where we can get caught up as professionals. A power of attorney can be a durable power of attorney, which means that it is effective no matter how or what happens in your life. I have Mary sign a power of attorney, and 3 years later, she's in a really bad car accident and she's in a coma. The power of attorney is still in place because it's durable. It still exists. It is in effect because she doesn't have the ability in that moment to make decisions on her own. It still exists. It's still there. Powers of attorney can be executed and effective as soon as you sign them. I sign a power of attorney giving someone the authority to sell my house, and it's effective as soon as I sign it, all the way until the house sells. No end date, just when the house sells. So the power of attorney is effective as soon as I sign it till whenever, without any definition of, oh, I have to have a disability or not, which is the next piece, which is springing power. A springing power of attorney only comes into effect if or when I can't manage my own affairs. And two doctors say, oh, Lisa's not doing well medically. These two people, we're saying she can't manage affairs anymore. Now Mary needs to step up and do business for her. And powers of attorney can be special or limited. I mentioned them a couple times. I can give a power of attorney to Mary solely for the purpose of selling my house. I can give Mary the power of attorney, or my power of attorney, simply to make my medical choices. I want to give her the power to deal with a credit card issue that I got myself into because I can't deal with the credit card company anymore and I need some help negotiating a settlement. So with taking all of this information and putting it in the hopper, the most important thing I can say to anyone is that if you've seen one power of attorney, you've seen one power of attorney. And in order to determine whether the power of attorney covers the scope or the authority of what you are looking at, you have to read it. When you do sit down to sign the power of attorney, you do decide at that time, I saw this question pop up, whether it's durable, general, or springing when you set it up. Yes, you decide all those times in that moment, and you also decide scope. So for example, if I'm helping someone who needs help with educational issues, financial issues, and medical issues, my power of attorney may have just contractual, because that's educational, legal, and financial authority granted to the agent. So the scope is defined before you sit down and sign it. Some folks do them very broadly, and some folks do them very, very narrowly. A power of attorney remains in effect for as long as the document says it's in effect, or until or unless the law changes. And what do I mean by that? If I do a good example of a specific power of attorney is when people get called up for duty overseas in the military. And right before they deploy, they'll sit down and do legal documents with attorneys that live near the base. I say that because we do them over here by Selfridge all the time. And the soldiers will tell us, I want to give power of attorney to my parents or my spouse or to whoever to cover these decisions. And the scope of the power of attorney is for the length of their deployment. And when they come back, they can choose to enter into another power of attorney that has a different scope, or they can choose not to. But in their situation, they have a specific period of time that they're going to give that authority away, and that's the length of their deployment. So when you talk about powers of attorney and using them to support folks, what do you need to do? You need to understand, if you're reading a power of attorney that someone has signed, that a determination has been made by the attorney who executed with them that the person who's signing it had the capacity at the time that they signed it. If you're concerned about whether it's still in effect, you need to look for its durability provision. Does it remain in effect when maybe you're seeing some signs of dementia, or you're seeing some signs of confusion that you can't tell were there or not there at the time the person signed the document? Is the power of attorney effective by date? If there's no end date in the document, then the document's effective. Does it cover the issue that you needed to cover? Is it a medical power of attorney for decisions about medical issues? Does it have financial authority in it for a financial decision or a contractual decision? If you're confused about the power of attorney and whether it does what it should do, you should send it to your legal department if you have any questions or concerns about it at all. The reason for that is that you don't want to make a mistake about what the scope of the authority is and tell someone that it's not appropriate or legal if indeed it actually does meet the standard or meet what you need it to meet. So powers of attorney can be anything you want them to be. They can be specific, they can be general, they can cover all kinds. Is there a fee to have someone help with a power of attorney? And the answer is, if you have an attorney do a power of attorney, they're most always going to charge a fee. There are legal forms that are available that are appropriate on the State Bar of Michigan's website for the estates division. I'm trying to think of the formal name. The Probates and Estates Division. There's a form there that folks can use. What you want to be really, really sure of is that when you pull that form off the internet, that one, it's a Michigan form and it complies with Michigan responsibilities. And if you're having an individual sign it, it has 4 things. First, that you've signed it. Second, that there's 2 witnesses. And third, that there's a notary. Okay. I think I saw a question. It goes back and forth a little quick, but can I do a power of attorney for, well, let's say you want someone to make your medical decisions and someone else to make your financial decisions. Can I do 2 separate? Absolutely. Again, we go back to scope. If I want Mary to make a medical choice for me, but Mary tells me, I don't want to manage your money problems, lady, and I pick Vicki to manage my money problems, I just have to do 2 separate documents. The other piece that's really important is that Mary has to agree to be my agent. She has to accept the responsibility that I'm asking her to take. If she doesn't accept that responsibility, no one can force her to do it. So it's important that when you execute a power of attorney, you recognize that your agent, the person that you're naming, has to accept that responsibility. Additionally, an agent, so when you write a power of attorney, you can do it. The beauty of them is they can be whatever they need to be, but you can also say, I want Vicki and Mary to be my agents under my power of attorney, because sometimes Mary takes me to the doctors, but sometimes Vicki takes me. And I want them both to be able to hear what the doctor's saying, or to be able to call the doctor when I'm not available, or be with me. So you can choose either one of them. You can say that they have to agree. You could say they can act jointly or independently of one another. You can say, I want this agent, but if this agent isn't available, then the next agent. And you can say, I want Mary, but Mary has the right to say no. And if she says no, then I want someone else. So the power of attorney is a very, very, very flexible way for you to be able to choose who helps you with your decision making, and who you are saying to the world, I am choosing this person to make my decisions for me because I need that help. So in general, one of the things that you've got to do when you read these is understand what the individual has given. And I want to stress this very strongly, because powers of attorney, when I do a power of attorney, it doesn't, when a person writes a power of attorney or signs a power of attorney, it's a voluntary engagement, and you're making the assumption that you're choosing the people that would make the best choices for you. But you have to recognize what authority the individual has given to the agent, and whether they've retained anything for themselves in that moment. Okay? So when you pick your agent, you really want it to be someone you trust. Okay? Because the scope of the document may give them the authority to be able to go into your bank accounts at any time. As I mentioned, it can be a list of people or more than one person at a time. But this is the next key. Must follow your instructions to the best of your ability. Okay? So if I appoint Mary to be my agent under my power of attorney, she's supposed to work with me and partner with me to help me do what's in my best interest. Does that mean she can do something that is not in my best interest? It does, if I gave her that authority to do so. Okay? So, for example, if I say, Mary, you are in charge of my money, and I've given you full authority over my money under my power of attorney, and I want to go in and take $1,000 out because I heard that if I give $1,000 to this guy in Mexico, he's going to send me a free iPad. Okay? And Mary says, Lisa, first of all, $1,000 isn't free. And second, I'm pretty sure he's not sending you an iPad even if you send him $1,000. And I say, Mary, you're my agent under my power of attorney. If I have given her the authority to make my financial decisions, Mary can tell me no. I'm not sending them $1,000 to Mexico to get you an iPad. Okay? What do I have the right to do then? I have the right to revoke and tear up that power of attorney and go to the bank and get the money out. But then I have to explain to the bank what I did with the revocation. And that's where that circle of support comes in. And that's where those making informed choices and decisions come in. Because at that point, if the bank is acting under the power of attorney, it is not likely they're going to say, Lisa, here's your $1,000. We know Mary doesn't care. They're going to say, where's Mary? Because Mary does your banking. So be very clear that when you give away, when you're assigning a power of attorney, what are you assigning to that person? What are you saying they're going to do, and when is it effective? And know that that person may be acting in your best interest, and it might not necessarily be what you think is your best interest in the moment. If you are someone's agent, you want to keep good records, whether they are financial, medical, whatever they might be, so that you can show a person, because at any time, if I say, hey, Mary, where's my $1,000? Mary can say, Lisa, it's right here in the bank. My favorite question right now is, where's my stimulus money? Right? Because I've got that question coming at me 7,000 ways from Sunday. Stimulus money goes into my bank account and my agent's in charge of it. I get to keep it for a year, but if I want to spend it, I'm going to talk to my agent about how. So when I do a document like this, I do one other document companion with the power of attorney, which is the next slide. I do a patient advocate. And
Lisa, can I interrupt with a quick question from the chat that I'm not sure we've gotten to yet?
Yeah,
the question's from Christine. It says, I am making a call for someone over the phone, for example, to talk about a credit card bill. Yes. The customer service rep usually says they need to get the authorization from the person to talk to the caller. How do you prove you are the POA over the phone? I hope this makes sense.
It absolutely does make sense. And what happens a lot of times is that if you say I'm this person's agent under their power of attorney, they're going to request that you send a copy of the power of attorney. So it may be that you have to forward the document to the company in order to prove who you are when you're making that decision or that call. Okay. There was another question that came up. Are there any other documents that trump the POA, i.e. a guardian? And the answer is guardianship. And the way that the question was asked, the answer is yes, guardianship trumps power of attorney. That's a whole nother topic or a whole nother issue. The major difference between the two is that you've proceeded to court for a competency determination from a judge. So using that analogy, if you have a guardianship, a court has determined that person doesn't have the ability to do something like a power of attorney in a lot of cases because of the scope of the guardianship. Powers of attorney are documents that we use very flexibly for all folks. Age, ability, it's really the engagement of the individual with their attorney. The patient advocate, I just wanted to bring up for you guys, that's a really, really fact-specific document. I know we're talking about powers of attorney primarily, but sometimes we're worried about what happens at the end of our life regarding our end-of-life choices. Do we stay on life support? Do we not stay on life support? And we want one specific person to make that choice or decision for us. What we need to recognize is that there is a state statute that appoints your next of kin to make that decision or choice for you. If you don't want that to be your next of kin, you would like to choose a friend, or you have someone who has a different belief system or follows your belief system regarding end-of-life choices, you might want to do a document called a patient advocate that would put that person in charge of that one issue. Okay? And I bring it up just because in a powers of attorney, when I write them, I don't usually include this authority, because so many times when we do a power of attorney, we're giving the ability to make medical decisions in general, in addition to legal or financial. But if you talk to someone, the people that they trust most to make a really significant end-of-life choice are not the same people who are spending their money, or vice versa. I have two amazing sisters, and one of them is fantastic with money and the other one is really compassionate. Guess who does what? Okay. Well, I guess I could name the compassionate one to manage my money, but I'd never have any money because we'd always give it to the Humane Society. Maybe she'd give it to the ARCs, I don't know. But she likes to donate. So again, what's really important about these documents, and I can't stress it enough, is that as an attorney, when I sit down with a client, I am assuming that my clients don't read what I write. I am assuming that they're expecting from me to explain to them in a way that's professional, appropriate, and in a way that they understand what it is they're about to sign. And that I'm going to do it in a way that they can understand what power they're giving to someone else, and what is expected of that other person. I assume that everyone that walks into my office has the ability to sign the paperwork if I am good enough at my job to explain it to them in a way that they can understand. And that's imperative. If you don't believe or you don't feel that everyone has capacity, you're always going to struggle with this concept. So I go back to the law and I say, the law presumes capacity for every 18-year-old. So why do we do any less? I'll leave it at that. I haven't seen anything pop up that I think we missed. I kept it right to 1 hour because I thought if we had questions, I would stay as long as you needed me to. Oh, there's a list of sources for you guys to take a peek at. The last two are really boring because it's just the law. The 5 wishes is really interesting, and the Bazelon Center for Mental Health is another good one. What about health advocates? Health advocates would be similar to the patient advocate, or a health advocate would be a document that's separate from a power of attorney where we're simply saying, I'm appointing this advocate to make my health decisions or health choices. Again, the scope of the document dictates what authority you're giving. And I'll give a real specific example about that. I had a situation where an individual was choosing to stay outside when it was really, really cold. Despite our best efforts to help him understand that there was a place for him to stay that was warm, and for him to come out of the cold when we had those sub-zero temperatures, right? And during that period of time, he contracted frostbite because he was staying outside.
Lisa, I think you froze. Let's give her a minute. She may have to log back on.
Yeah, she literally froze mid-sentence. I wonder if her internet.
So Lisa, you're frozen if you can hear us.
I'm going to send her a quick email, Vicki.
Okay. Hang there with us because we're going to take questions. So you can think about what kinds of questions you might want to ask. But she has to finish telling us that story, though. I want to know what happened to the individual. So we do have a question about the recording. We don't have the recordings posted yet, but I'm hoping that we can get these on our website here in the near future, or at least on our YouTube channel. I will check on that. And
Vicki, we'll be sending out the PowerPoint, correct?
we can do that. Mm-hmm.
So that's something you could also choose to share while they're preparing to get it on the website. So I did send an email to Lisa in the hopes that she'll be able to sign off and sign back on with better success. And what we can do, if you have a specific question, if you want to put that into the chat, if Lisa is unable to sign back on, I can forward those specific questions to her in the hopes that she can send you a response. Okay, I see a question from Alana. Hello, you mentioned that a medical POA is intended to help an individual make medical decisions. Does this necessarily preclude an individual from making their own medical decisions? With Lisa, are you back?
Mary, I am. I don't know what's going on. I'm online, but I can't see you guys, so I called back in.
Okay, so here we were just going through, I was just having people go ahead and write questions in the chat, and I was going to forward those to you. So I'll just read that to you. It says, hello, you mentioned that medical power of attorney is intended to help an individual make medical decisions. Does this necessarily preclude an individual from making their own medical decisions without consulting or getting input from the medical POA? Should they wish to make such a decision on their own?
So the answer to that depends again on the scope of the document. Okay, and that the hardest part about a lot of these answers is specifically what does the document say? Did I give that full, if I've given that full authority to the agent, then I've given that authority to the agent, and the agent must be part of the decision making. If I reserved that right, unless I'm not in the situation where I can make that choice, then I can, if I've reserved the right to make the decision, only give it to my advocate when I can't make the choice, then I've reserved the right to make the choice. So it depends on the scope of the document.
Okay. Elena, if you just want to put back in the chat if that answered your question, or if you have a further follow-up. Okay, go ahead, Lisa, and then I have one more comment in the chat.
Okay, and one going back to the conversation about the medical. When the reason the scope, I was telling the story about the guy who had frostbite, right?
Mm-hmm.
Well, the power of attorney the individual executed only allowed the agent to make decisions regarding general medical procedures.
No, I
and
just
an amputation for a frostbite was considered more than a general medical procedure. So the power of attorney was not sufficient for the agent to agree.
Okay. So what we hear you saying, Lisa, is, they can be worded very specifically for your individual set of circumstances.
Sorry, Lisa.
Right.
Muted you. There you go.
You're muting me.
Sorry about that.
So yeah, that's okay. Yeah. So you have to. So yeah, Mary. Going back to just to reiterate, the scope of the document is imperative in determining what level of authority the agent has.
So, for example, Lisa, a couple years ago when I had surgery, I did a a medical power of attorney for my, at the time, 21-year-old son, and I chose him because I thought he would make decisions if there was complications in surgery and I was unable to speak. He would make the decisions that I had told him ahead of time I'd want him to make versus my siblings. And yes, I would say the hospital raised one eyebrow when they're like, a 21-year-old, you really want that person making your decisions? And I said, yes, but it was written very specifically too, that only for that specified period of time or under those circumstances based on being unconscious for that one surgery. You know, he has no authority over my medical decisions now. He can't decide whether I choose to be on birth control or whatever. It can be very narrowly written. So I've experienced that just from the family perspective as well.
It can be very, very narrowly written. And in addition, you might change who you want to make your decisions in the future.
Yep.
So for example, if I pick my dad to make my decisions or choices, and I realize that, wow, gosh, my dad isn't going to do what I want him to do because my dad will keep me alive forever because he's my dad, I can change that document to someone who's going to do what I would wish if I were in that situation.
Right.
You're retaining the right to change who's helping you with your decisions or choices. The same is true as for finances. If I appoint someone to manage my finances and that person isn't doing a good job, I can always choose someone else to make my financial decisions.
In my brother's situation, he had a patient advocate that was somebody from his church. He felt like that person knew more about medical information than, you know, others in our family, but also that individual is now moving to a different area and will, for all intents and purposes, probably have a lot less contact. He's moving out of state. So one of the main differences in my mind between like a guardianship and a power of attorney, you can change them more easily than you can, you know, if somebody has like a full plenary guardianship, the person's retaining the choice of who is chosen to make decisions and the particular scope, and it's easier to change that.
And most importantly, in a recognition of something really is that when you do a power of attorney, we're not declaring that person incompetent. We're saying that that person's capacity allows them to make these choices with the help of their circle or whoever. If we do guardianship, we've declared them not competent. So they can't change anything unless they go back to court, and the court decides for the person, not the individual.
Yeah, that's a great point that, you know, the court, once you go to guardianship, go to court, the court makes decisions versus if you're doing power of attorneys, then you and your circles get to make decisions that are best for you. This is sort of a loaded question, but what's the pros and cons of, you know, just supporting someone and helping them with their finances or their health decisions versus putting in a power of attorney document, you know?
The answer to that, Vicki, is that I think it goes back to circle. And it goes back to people having the ability to make choices and decisions. And in my opinion, I think that everyone should have the opportunity to fail. Because by failure, we learn what we don't know, right? I think sometimes as family members, we struggle with that idea of dignity. We call it dignity of risk, right? We're going to take this risk, and if it doesn't work out, boom, we're going to protect this person from making this mistake. So I think sometimes that we do these documents because we want to help people make more informed choices with less risk before we allow for the opportunity for risk. So the pros and cons of helping someone without any of these documents, I'm an attorney, so I'm just going to say I think every single human being over the age of 18 needs a power of attorney that says if there's ever a time in life where you can't do something, this power is given to someone I choose and I trust to be triggered at a time when it's necessary to take care of my affairs so I don't end up in court. Because the only option, if something happens, if I got in my car today and I had a car accident and I couldn't pay my bills because I couldn't write a check or I couldn't go to the bank because I'm in a coma, the only way that my family can do something for me is if I have a power of attorney that says who can manage my affairs. And if I don't, and there's nobody else's name on my account and there's nobody else who can manage for me, it's guardianship through the probate court. So the pro and con to doing something, the pro is that if you do something, at least you have something in place that if there's an accident or a challenge, there's someone there to help you. I can't think of a lot of cons if the relationship between the two individuals is good.
Yeah, and you bring up a good point. I think our next March session is about financial tools. And so, as you mentioned, having other people, having joint accounts, and there's some other ways that folks can do that. So, you know, with these trainings, we're trying to present all the tools that are at people's disposal that would assist them and to leading the, you know, the most autonomous life that they can have.
There was a question that popped up, Vicki. It said, is there a recurring fee for a power of attorney? But I couldn't see the whole question. Can you see it?
The full question is, oh, and another question just popped up. So the first one is there a recurring fee for a power of attorney if they help with a document and revise it?
It depends on the person who wrote it.
Okay.
Okay. Like if I write it, then there's not usually a recurring fee. If you go to another attorney, I can't tell you what they would do.
Okay. Can you give out just sort of a general window of what those fees might be, say per hour or per contact?
I can tell you that here at the Arc of Macomb, we usually charge $300 for them. I do know that one of the things that we do is if you want to pay $5 a month for the rest of your life, you can do that. My experience with bigger firms is that you really have to find an attorney who is going to pay attention to philosophy as well. But I think we're a little bit, I know that for us here, we're at the lower end of cost. And we adjust when families struggle. So there are also legal aid company organizations who will also do them.
Okay, I just wanted people to have that sort of general idea. Sometimes we get questions at DD Council of, you know, somebody said it's going to cost us $5,000 for a power of attorney. Is that normal? Is that typical? And I wanted people to have kind of that window idea in their mind.
$5,000 would be a luxury estate plan, yeah.
Yeah. And this is for a person with no employment, no income other than benefits.
No, that's a lot of money.
Yeah. So, you know, I wanted people to kind of understand that window. And then we have another question from Michelle. There have been experiences where there is a power of attorney, but a doctor will not recognize it because the doctor feels the individual did not have the capacity to sign the POA. Suggestions for how to handle these situations. Doctors are pushing for guardianship versus POA.
I always ask if they sent it to legal. Again, and this actually just happened to me, where a doctor said that they said the person didn't have capacity when they signed it. And in this particular, you know, first of all, the capacity is determined by the attorney at the time the document is signed. And unless the doctor was present at the time the document was signed, he wasn't there to determine capacity. Second, what they're most worried about is liability. Okay, so a lot of times if you say to the doctor's office, can you please send this to your legal department or the hospital's legal department, they'll okay the document. There may be situations where they absolutely won't accept it. And at that point, it often depends on where you are in your medical process on what choice you make next. What I will say is that technically the doctor doesn't have the ability to determine capacity because they weren't present, and it is a legal and binding document. Again, it goes back to, did you send it to legal yet?
I had that very experience with my brother as we were standing in the emergency room, where a doctor was saying, you know, when I walked in, he had already discussed with my brother that my brother needed a guardian because he couldn't give informed consent. And of course, as an advocate, that didn't sit well with me. So after a conversation involving those very, very tools that you're talking about, Lisa, where, you know, we talked about, well, feel free to send that to your legal department, but here's where I work, here's who I work for, and this is what I'm telling you is legal. You know, we're happy to put our lawyer up against your hospital's lawyer, and they really, I mean, it's just strong advocacy, and you have to know the information that you've obtained from this presentation today and be willing to kind of give a little pushback. In that situation, the hospital, you know, we ended up also on the phone with the legal department, and they said absolutely it's valid.
One of the things that I like to say when they tell me that I can't give informed consent is to say, well, you didn't explain it to me in a way that I feel informed. Yeah. I mean, you know, that's the key to they can say the key. Remember, going back to informed consent. Informed consent has a component of explanation that's understandable to the individual who's receiving the information. I'd argue a lot of us lack informed consent when they're yelling at us in an emergency room.
Well, yeah, I mean, in that situation, you know, we drew pictures, we explained, there were multiple family members in the room that helped to explain it in a way. And once we started discussing what our understanding of what the doctor had just told him, the doctor started to realize, oh, I have a role in explaining this in a different way. And so, you know, we pushed back, and it was helpful. What we've also put in place too is we made sure at both hospitals in our area that he has what we call medical information sheets that describes in his record how to explain things. So if he gets there before we do and aren't there to explain for a few minutes, people can see right away, oh, this is how I need to explain this information to him. Here's people that I need to call. You know, we have our cell phone numbers on there. So that's a piece that also helps. It helped discussing that with legal departments as well. Like, he obviously thought this through. He had the capacity to have somebody send these documents to us ahead of time. So this isn't, you know, he's just making willy-nilly decisions. He's thinking this through. And so that's how that specific situation happened.
Excellent.
Lisa, could you know, an advanced directive is my understanding, so is a legal document. So how does that fit in or differ from a power of attorney?
So usually advanced directives are specific to an end of life choice. And they're saying, this is the person I'm choosing to make this decision for me, and under what type of conditions. For example, the doctors are saying that there is no brain activity and they want a decision about who's going to continue life support or not. Those are typically what an advanced directive covers. And then the individual who's making the decision is making it based on conversations or information they have from the individual who assigned them, regarding what that person would choose if they could communicate their wishes.
And are you familiar with the psychiatric advance directive?
If the conversation of a psychiatric advance directive has to do with Kevin's law, then I would say yes. It's typically a situation where when I'm healthy and I know that I might need help at a time when I'm not healthy to make that choice, I'm appointing someone to make this choice for me. And the scope of that document dictates what the individual is allowed to consent to, but it gives the ability to the agent to coordinate psychiatric care when I might be saying no and I really need help.
Yeah, and it can also give very pertinent information about your wishes when you're unable to express those wishes, which hospital you might prefer, medications that you don't want.
Yeah, and I've seen them actually where they name people who you feel safe as a therapist or a psychiatrist, or even whether you're comfortable with certain types of treatment like ECT.
Right.
So again, the scope defines the authority. The key is that it's signed when the individual is feeling healthy and makes the choice. And another more important concept with it is that if the individual is presenting as if the document needs to be activated, they can't then say, I don't want the document right then. They get treatment, and then following the treatment, if they want to change the document, they can.
I've also experienced situations like that with some of the folks that I've worked with over the years. A classic one that I've seen written in a couple of those documents is if somebody is not taking their prescribed medication for more than X number of days in a row. So for a person who cycles, starts to do really well because the medication is supporting them and they've agreed to the medication and all of that, and then starts to think, well, I'm doing so well, I probably don't need that medication anymore. Then they stop taking it, things decombust in their life. And so, in that period of time where they were doing really well, they have the paperwork signed. And if they haven't taken their medication in X number of days, and that could be written, within that scope, then the authority goes to somebody else.
Right, and again, it goes back to every one of these documents is specific to how it's written, who's appointed, and what language you put into it. And that's why it's so imperative that when, as professionals, if we're reading documents, or family members, if we're reading documents presented to us, we don't presume that they say or do one thing or another. We have to really pay attention to what authority is being granted and in what capacity.
Okay, do we have any other questions or comments from anybody?
I don't see anything else popping up in the chat. As soon as I said that, now there's another one. Are there templates that are available that we can use to craft our document, or at least create a draft?
Yes, if you check out the State Bar of Michigan probate section for the State Bar, they have some forms up, as does the Elder Law and Disability section for the State Bar of Michigan. So it's on their websites.
Okay.
And I'd just like to say thank you for having me.
Yeah, Lisa, yeah, so that was, say that again, State Bar of Michigan under the probate section, and then what was the other one?
The Elder Law and Disability section for the State Bar of Michigan. Same website, different section of the bar.
Okay. All right.
All right.
Well, I have to say, one of the things that really stood out to me in what you said was, because I really hadn't thought about this way, is that, both, whether you seek guardianship or you want to use power of attorneys, both require some thought and work, right? But guardianship, as you mentioned, the court controls, and if you want things changed, you have to go to court. They have to agree to it. They have the control over what may or may not happen. If you choose to use power of attorneys, then you have more control over the decisions of who's going to support you, and if you want to change things in the future, of who's supporting you in various areas. Did I summarize that okay?
You did great.
All right. So,
Lisa, I just want to reiterate what many are saying in the chat right now. Just thank you. This has been a wealth of information. I call you a walking, talking encyclopedia of power of attorney, because I think you have a really good, way of describing it too. I don't always understand legalese or medicalese, but you present it in a nice way that's understandable.
yeah.
So
Thank you very much. And if anybody has questions or things afterwards too, my number was up. And thank you, Elizabeth Martin. I appreciate it.
oh
She
my
said-
gosh,
she
is
said
it your
happy
birthday today?
It's tomorrow.
Oh, okay.
So
Thank you
just
so
remember,
much, everybody.
So early happy birthday. Thanks, Elizabeth, for being so kind about that. Again, if you want right CEUs, you need to email Jean. Jean, if you're still on, if you could throw your email address in there. If you could complete the survey, I believe Caitlin has put that in the chat. If we could go to the next slide just before we finish up, I do want to give a plug for our upcoming sessions. So as I had mentioned, March will be tools to support financial decisions. We'll talk about Wills Trust, ABLE accounts, and other types of trust in April. We're going to talk about how person-centered planning is part of supported decision-making. It's that person-centered plan and how that's developed, and person-centered planning is just so important. And what I always tell people, we all do person-centered planning. You know, we all have to figure out, what do we want in life? What are our goals? Who's going to help us? My two sons don't have a disability. When they were turning 18, we kind of did this. We sat down and talked about goals, and then how they were going to accomplish that. So it's just, that is just a fantastic process that's really, really important. And then we'll talk about life course tools. In June, we'll talk about circle of support, which as Lisa had mentioned and Mary's mentioned, and I probably mentioned in the past, we all have a circle of support. And so it's important who is a part of that and how do they, and then, you know, for some people, how do you create that circle of support? So another great session. We're talking about assistive technology in August, and healthy relationships in September, and then peer services as a way to support people in October. All of our sessions run from 1 to 2:30 or 6 to 7:30. Any other comments or thoughts before we close out?
Just a quick point of clarification. It's going to be Kathy McRae next month. I think you said Mark, which confused me. So
No.
yeah, it's Kathy McRae from ARC, Michigan.
Yeah, I think I just said March. Maybe I didn't.
Oh, okay. I thought you were saying Mark, and I was like, no, we talked about him for maybe power of attorney, but then we just wanted Lisa to come.
Yep. So yeah, we're excited, and nothing else. We'll just hang on for a few minutes, let people finish their survey, and write additional comments. So thanks again so much for being a part of this. If you know of individuals that would benefit from this, please don't hesitate to pass on the flyer when we send it out. The March flyer will be coming out in the next week or so. So stay tuned for that.